You bought shares in a company yesterday, so you are a member of that company now, right? Wrong. You might be a shareholder and still not a member. Most candidates get this difference wrong and lose an easy mark. By the end of these 10 minutes, you will never confuse the two again. Let's get into membership and transfer of securities. So, what we are going to see in this topic. Number one, who is a member and the three ways of becoming one. Two, register of members, the records of a company must keep. Three, the big one, members versus shareholder. And four, transfer of securities, how shares change hands. Five, transmission, how shares pass by the law itself. Stay till the end. The last 2 points are where the marks are. Who is a member? Section 255. Section 255 says a person becomes a member of a company in any of three ways. One, a subscriber to the memorandum. These are the people who signed the company's founding document. The moment the company is born and incorporated, they are members automatically. In simple terms, think of a few friends starting a cricket club and signing the club's founding papers. The day the club is registered, those signatories are members. Nobody has to add them later. They are the members by birth of the club. Now, this is the first method of becoming a member. Two, a person who agrees in writing and holds shares. You apply for shares or shares are allotted or transferred to you and your name is registered in the register of members. Note both parts. You agree in writing and your name goes into the register. In simple terms, you join the club later, you fill the form, pay, and the club writes your name in its member book. Now you are in. 3. A beneficial owner in a depository records. Today, most shares are held in DMAT electronic form. If your name sits in the depository's records as the beneficial owner, you are a member. In simple terms, DMAT is like a money in your bank account instead of cash in your pocket. You own it, it is just held electronically. That's what you get when you buy shares through the stock market. Now, the company has to write all these members down somewhere, and that record has its own set of rules. Watch this. The Register of Members, Section 88. Under Section 88, every company must keep certain registers, a register of members with the details of their holdings, a register of debenture holders, and a register of securities, of other securities. And here's a number the examiners love. If the number of members exceeds 50, the company must also maintain an index of members, unless the register is already kept in an indexed form. In simple terms, the register of members is the company's official who owns what ledger, like the voter list of a company. And once you cross 50 members, the law says keep an index too. So any name can be found quickly, just like the index at the back of a thick book. Two more points to remember. The register is prima facie evidence of membership and title, meaning it is the first proof the law accepts that you are really a member. It is kept at the registered office and it is open to inspection. And a company may keep a foreign register for members living abroad. So the register decides everything, which brings us to the question that trips up most students. Members versus shareholders, the key distinction. A member is a person whose name is entered in the register of members. A shareholder is a person who holds shares. Usually, they are the same person, but not always, and the gap is exactly what's tested. In simple terms, imagine a member only club. You can buy a membership share from someone, so you hold the share. You are the shareholder. But until the club writes your name in its registers, you cannot vote at the meeting. You can't walk in as a member. You hold the share, but you are not a member yet. Two classic examples. Memorize this. One, a subscriber to the memorandum is a member even before shares are allotted to him. He signed the founding papers, is a member first and holder later. 2. A person holding a share warrant, a bearer document, or an unregistered transferee, someone who bought shares but hasn't been entered in the register, yet is a shareholder but not a member. So, the rule to lock in holding shares makes you a shareholder. Getting your name into the register makes you the member. You can be one without the other. Transfer of securities, section 56. Now, how do shares actually change hands? Two ways, transfer and transmission. First, transfer. A transfer is a voluntary act between the transferor and the transferee. For it to be valid, a proper instrument of transfer, that's Form SH4, duly stamped and signed, must be delivered to the company. The company then registers the transfer and issues the certificate. In simple terms, transferring shares is like selling your flat. You just don't hand over the keys. You need a proper stamped sale deed that both the buyer and seller sign, and it has to be recorded. Form SH4 is the sale deed for shares. Now, two key rules. Public company shares are freely transferable. That's section 44. Like selling a listed stock on the exchange, no permission is needed. A private company restricts transfer through its articles, like a family business, where you can't sell your shares to an outsider without following the family's rules. And if a company refuses to register your transfer, you are not stuck. You can appeal to the NCLT, the tribunal. So, transfer is when you choose to hand over your shares. But what if the owner dies? Nobody choose anything, yet the shares still have to move. That's our final concept. Transmission versus transfer. This is the pair examiners love to contrast. Transfer, we just saw, is by act of parties, a voluntary sale or gift. It needs an instrument of transfer, SH4, plus stamp duty, and both transferor and transferee are involved. Transmission is different. Transmission happens by operation of law automatically when a member dies, becomes insolvent, or is declared of unsound mind. Here there is no instrument of transfer, no SH4. The legal heir or official assignee simply proves title, for example, with a succession certificate, and the shares pass to them. In simple terms, transfer is like selling your house. You sign a deed and hand it over by choice. Transmission is like inheriting your father's house. You didn't sign any sale deed with him. The law passes it to you. You just show proof that you are the rightful heir. So, one line contrast. Transfer is equal to you hand it over SH4, that is the kind of a sale deed, plus stamp duty. Transmission equals law hands it over due to death or insolvency, no SH4. Here's a quick recap of what we have learned. A member is section 25, is a subscriber to the memorandum or someone who agrees and is entered in the register or a demat beneficial owner. The register of members, section 88, is prima facie evidence and needs an index once members cross 50. A member has his name in the register. A shareholder merely holds shares, not always the same person. Transfer is voluntary and needs Form SH4. Public shares transfer freely, private companies restrict transfer. And transmission happens by operation of law on death or insolvency with no SH4 needed. So if a friend says, I bought shares, I'm a member now, you can correct them, not until your name is in the register. If this made the members versus shareholders difference, click, hit like so it reaches more aspirants. The free notes and 10 MCQs are in the pinned comment. Go test yourself and comment your score below. Next lecture will be the company management, the directors. Subscribe and I'll see you there.